Hello, my name is Professor Brett Davies and I'm a barrister and solicitor and partner at Legal Consolidated Barristers Solicitors. Now, we have an interesting situation with superannuation. Its sole purpose is for your retirement, and therefore when you die, your superannuation has to come out and be paid to your dependents or your estate, or if you have no will, then according to a government act. But there are two ways of actually keeping your superannuation in your super fund. They're not very common, but they are a good resource for your financial advisor and accountant to use. The first are reserve accounts. So if, for example, reserving accounts are normally kept so you can balance out returns over the years, have many other purposes. But when you die, the reserve accounts can remain in your super fund for your spouse or your children, or anyone, your grandchildren, or anyone in your self-managed super fund. There's another way of retaining your superannuation in your super fund, and that is reversionary pensions. They are very useful, they're very tax effective. And in this situation, we had a mum that had a reversionary pension for her under 18-year-old child, her love child. And unfortunately, by the time she died, she hadn't sought any more advice from her accountant, lawyer and financial advisor, and she was unaware that once the child turned 18 and the child was no longer being maintained by mum, then reversionary pensions are no longer available. And I refer to Taxation Ruling 2013/5 from our friends at the Australian Taxation Office. They're good. The regulator will help guide you as to what the law is. Obviously, the regulator is not the person elected, so the regulator is often wrong in its rulings, but I think in this ruling it is probably correct. So in this situation, mum died, there was a reversionary pension, the corporate trustee was under the control of her executors named in her will, which were the two older brothers from a previous relationship, and they, after their mum died, took control of the corporate trustee. They then looked and got legal advice as to whether the reversionary pension was effective. They didn't know much about them, and unfortunately it wasn't. So they were now not bound, in fact could not be bound and could not follow mum's reversionary pension. They then asked their advisors as to what now happens with mum's superannuation in her self-managed super fund. And the advice, correct advice, was that it's at the discretion of the trustees of the self-managed super fund. And after talking to their wives, they decided to pay out 100% of mum's superannuation to themselves and nothing to this younger half-brother love child of their mother. So unfortunately, mother may well turn in her grave, but there's nothing she can do about it. And this is why when you are doing estate planning, you've got to cleave to the breast of your three advisors, your accountant, your financial advisor and your taxation lawyer. These are complex issues at death, major tax planning opportunities. It's no longer the case you just go to one of those professionals and get wills and things done. You've got to make sure that you're getting a full holistic service from those three professionals. Enjoy the service that our law firm provides and enjoy the website as well. Enjoy.